Thank you very much. And let's start with the current status of the Hungarian company regulation. And we are in an anniversary period because we have 10 years in force of the actual regulation. We have a super money system, which means of course, from the point of view of law of obligations, that there are no differences between civil and commercial obligations, but from the point of view of the companies, that means that even the company regulations are included into the civil code. The third book of the civil code is on legal persons, and that contains, beside other types of legal persons, also the rules on companies. And this is perceived something like reform, and indeed it's a reform, but it's also a complication for students and practitioners. Why? Because in the civil code we have now in the third book 3 layers of regulation. We have the general rules on legal persons, we have the general rules on companies, and we have the specific rules on each type of company. In Hungary we have 4 types of companies. So we have these 3 layers of regulation, and this leads to a high level of abstraction, and the text is shorter compared to the previous disparate way of regulating instead of this kind of codification approach. We can say that somehow maybe 16, 18, something is that the percentage by which the text is now shorter than when we had the company law outside the civil code. But what is the complexity? Let's take one simple example, supervisory board. We have rules on supervisory board in the general rules on legal persons, not a set of rules in the general rules of the companies, but we have specific rules, for example, for joint stock companies. So if we want to solve a legal problem, we have to use in the very same time 3 regulations in the same code, but in different parts of the book 3 on legal persons. And this raises the issue of complexity for students to learn the text and for practitioners also to apply the text. But the text is shorter compared to disparate different pieces of legislation instead of the code. So these are the layers of regulation which are very important. The second issue is a conceptual change, and this is somehow resonates on the Czech experience because the percentage of default rules is increased to unprecedented high level. We have as I can say, we have something as an approach like contract law or classical civil law approach, because we have a general rule which says that everything in company law, which refers on the mutual relations of the members of the company, the relations between the members and the company, and organization and operation of the company are default and not mandatory. So this is the general approach. I mentioned that we have a rule of the default rules because everything is default if it's not provided otherwise. When it is provided otherwise, we have in the cited legal text some limits to deviation from the law. And of course, we see first a very simple case, a very at first sight, deviation is prohibited by the law. This is the first case. And the second case is a little bit broader. If the deviation is against the rights of creditors, rights of employees, minority member shareholders, and in the last case when it hinders the supervision of the legality of the activity of the company. So these are the limits, but in practice, this is not so easy to determine. Let's start with the first case. Deviation is prohibited by the law. Theoretically, this is easy, and yes, we have many cases when it's really easy. For example, we have a text in the civil code like if the law prescribes unanimity for the adoption of a certain resolution, then the founding documents, the articles of association, for example, cannot deviate because the sanction of nullity. This is a very clear text. We don't have problems with such kind of text. But we have other type of text. For example, anyone may inspect the share register. This is default or mandatory. There is no explicit sanction attached to this text. And here comes the great question. Okay, the previous text that said that the deviation is prohibited by the law. What does that mean in our case? And in one example, in one court case, the articles of association of a joint stock company said that anyone might inspect the share register, but they must prove that they have a legal interest in doing that, and creditors are presupposed to have that legal interest. And this case went to the highest court, to the Curia, to check the legality of this provision in the Articles of Association. And if we go back here to the general rules on default and mandatory character of norms, what we can find? The share register is probably something related to the organization and operation of the legal person, so it is included into the domain of the default rules. But of course, this can be debated as well. But there is no explicit prohibition for deviation. And the highest court said that no, this kind of rule, which limits the access of third persons to the share register to get the information which is in the share register, is a mandatory norm. So we have something which we can say that they are virtual nullities as well in company law, because the court considers that there are some issues in which the norm has mandatory character, even if there is no specific sanction of nullity attached to the norm. But the situation is complicated in other cases as well. For example, the law simply states that the mandate of managers is of 5 years. Okay, what we can do with this norm? It's mandatory or not. Internal organizational issue. So everybody says this is a default rule. So that's easy. But what if we set the mandate of the manager for 10 years in the Articles of the Association? Does that breach the right of the minority shareholder, for example, to express their choices on the components of the management of the company? So these are every time questions raised from this perspective. And there was one debate which I was participating in it. The initial version of the civil code said that and in joint stock companies, at least minimum 50% of the shares must be ordinary shares. And this is a mandatory norm, or it's a default norm. And I said that setting this percentage by the law must be mandatory, because there is no need for supplementation, substitution of intent, because otherwise, if we issue, for example, 30% of ordinary shares, that's automatically we have 30% of ordinary shares. So there is no need to substitute the intent of the shareholders in this sense. So it's not functioning as a default norm. And others said that this is something, a default norm. The joint stock company can issue lesser ordinary shares than 50%. The legal debate was ended by the legislator, who abrogated this norm. So now everybody agrees, I can agree with that, there can be joint stock companies without any ordinary share now. We can have a joint stock company which has different types of preference shares, for example. So this is the conclusion, but the legal debate, the theoretical debate, was solved by the legislator, intervening in this debate. Also an issue, it was raised today, the problem of registered and bearer shares. If the law says that a share is security, etc., it's issued in the name of the holder. Okay, but if this is the share, it's something related to the relationship between the company and the shareholder, so it can be a default norm. And if it's a default norm, what we can do, can we issue bearer shares then? And of course, the answer should be negative, but how we can explain that? Again, no express sanction attached to the of the breaking this rule, and how we can do that. The interpretation given by the highest court, it was that rule which contains a definition or elements which are strongly connected to the essence of an institution, they must be considered as mandatory. So the registered share is something mandatory which excludes bearer share, non-registered share. And okay, then if we apply this kind of argument, another issue was raised for a limited liability company, because the initial text of the civil code said that every member have one core contribution and will get one company share or business share, one share of the company. It's not like in the joint stock companies, it's German idea. And this was perceived as a mandatory rule. But okay, this is something which belongs to the traditional core essence of the limited liability company in Hungary. That was same in the 1930 legislation as well. But the others argued that no, this is not anymore. These must be considered default rules. The legislator again intervened, changed the civil code, And now it is expressly stated that one member of the limited liability company can have as many as possible business shares and score contributions differently, not more than one. So what is happening, and this is criticized, this prevalence of the default rules, and now it's mandatory that you can have more than one. Practically, it's criticized because something is happening in the sense of the core essence of the limited liability company is somehow dissoluting, and this kind of company comes together, comes closer to the joint stock company, and this is an issue which is very current, that we discussed today, that we are using numerous clauses of companies and so on, but the companies are moving on a scale between capital company and the company in which personal elements are really important. So if we take these default rules, the limited liabilities company's formal characteristics are in dissolution. And let's take another example why it's really hard to define which is mandatory and which is default norm. There is a text, I'm not sure you can read it, but it's interesting. For example, if you have preference shares in a company, and do you want to modify in a negative way the rights attached to the preference shares, you need a separate consent from the holders of the preference shares as well. This is the rule. And the second paragraph says that any provision of the articles of associations of publicly traded companies is null and void. So for a closed type joint stock company, this is mandatory or a default rule, because the law expressly states that for publicly traded company it's mandatory. But if we look at the case, for example, there are preference dividend preference shares, for example, and do you want to, I don't know, for example, make those preference smaller? That is default rule that you can exclude in the articles of the association the consent of the holders of those preference shares, because the company is not publicly traded. And it's a question, because if we go back to the general rules, we see that you cannot breach the minorities' rights, and that's a complex issue. What do we mean by minority rights? That covers individual rights or just the so-called specific collective rights of minority, which are explicitly named by the legislation. And we don't know, because the court practice doesn't clarify that until this moment. Let's take also example of usefulness of the para contrario interpretation. The law says, and this is very clear, doesn't need interpretation, that you cannot validly exclude in the limited liability company the transfer of the business share for monetary consideration to an external party. And this rule is rooted in the practice, because if you want to sell your business share in an LLC to an external party, the law gives a preemption right type of solution. the other members or the company itself or a third person nominated by the company have preemption right. And what this functions when the business share is sold. But in many cases, there was solutions like, okay, I make an exchange contract for shares traded at the stock market, or very vendable painting, or I make a donation and I get another donation in a different contract. So the preemption rights can be circumvented in many ways, and this interpretation, para-contrarian interpretation, is useful because the law says that a mandatory rule cannot validly exclude the transfer of business shares for monetary consideration. So if you want to prevent such methods to sell the company shares, the business shares, you must include a prohibition clause for exchange and donation in your articles of association. And you are not infringing the mandatory rule, but you are making an important limit in the transfer of business shares, company shares, to the external parties. And let's test our knowledge. What do you think? It's very simple. Right to participate in the General Assembly. Shareholder is entitled to participate in the General Assembly, etc., etc. This is the rule. And it was raised that it is default or mandatory. In which sense? Of course, you cannot put a guy with a gun in the front of the place where the general meeting takes place, and to avoid the presence of the shareholders. No, in some cases, there were clauses in the Articles of Association, such like the right to participate in the general meeting is linked, for example, to a certain number of shares. So if you have less than 100 shares, you cannot participate in the general meeting. Or another method used, it was that you can participate in the general meeting if your shares were registered at least 1 year before the general meeting's date in the share register. So this kind of texts were in the Articles of Association, and it was raised the question if this rule is mandatory or not. Of course, no sanction is attached to it, and the High Court and the other courts says that this is important because the individual right. The High Court said that this right to participate in the General Assembly cannot be limited in this way, and from this point of view, this rule must be considered mandatory. But to understand the complexity of the issue, another case, the general meeting was convened to a very small space, and all the shareholders could enter and to participate at the general meeting. And of course, it was raised the issue that the right to participate in the General Assembly could not be exercised. And what it happened, the High Court said that this doesn't lead to the nullity of the resolutions adopted in the General Assembly, only in the case when this limitation to participate is something which had a direct impact on decision making. So if we took a first interpretation, I have 1 share, the Articles of Association requires 10 to participate. That's absolutely infringement of the mandatory rule. But if I can go to the general meeting, the Articles of Association doesn't say anything on that, but I could not enter the space where the general meeting is held. That doesn't make the general meeting invalid, only in the case where I have enough power to influence the decision making in the General Assembly. So it is a question of interpretation of the same rule if in one case it's mandatory and maybe in other cases it can be perceived as default. Of course, many other interesting questions can be raised, but I think my time is gone.
More or less.
More or less. More?
Less.
Less. Thank you.